Bismillahirrahmanirrahim. Welcome to my business educational platform. Today we are going to discuss the chapter number 4 from the business law, that is about the free consent and the void agreements. So what will be the learning objectives from this chapter? So we will discuss part 1, that is about free consent. Then we will discuss the expressly declared void agreement in part 2. So let us discuss what the consent is. Consent shows the acceptance without any undue influence, fraud, or the misrepresentation. So as per book, two persons are said to consent when they agree on the same thing in the same sense. This is called consensus ad idem. If there is no consent, then agreement is definitely void. So what is the definition of free consent? The free consent is said to be free when it is not caused by coercion, undue influence, or fraud, misrepresentation, or the mistake. So coercion represents that there must not be any threat involved in the consent. So as per book, coercion involves committing or threatening to commit any act prohibited by Pakistan Penal Legal Code, or unlawfully detaining or threatening to detain any property. This is done with the intention of forcing someone into an agreement. So definitely burden of proofs will rely upon the affected party that will be affected from the threat. So what are the effects of coercion? Definitely voidable, there will be the voidable contract or the restitution, restoring benefits. What we will do in this, we will restore the benefits. So what we will do in the voidable contract, the contract becomes voidable at the choice of aggrieved party. The party that is affected from the coercion or the threat, definitely it will rely on this, if it makes it the void or it makes it the voidable. So then we have the restitution or the restoring benefits. If the aggrieved party decide to rescind, cancel the contract, both party must return any benefits they received from each other. So if any party wants to cancel the contract, it can cancel, but they can get the benefits that are being involved into the contract. So then we have the undue influence. What is the undue influence? A contract is considered to be under the undue influence when one party is in close relationship or has a position to dominate the will of the other party. So either there must be a relationship, there will be the relationship, then we have the undue influence, or there is the dominant of the will of the other party. So the dominant party uses this position to gain unfair advantage. If there will be the dominant party, certainly it will use the unfair advantage in the agreement. So I hope you understood the undue influence concept of undue influence. So what are the examples of relations that are involved in the undue influence? Or there is the undue influence assumed. We have the authority based relationships, we have fiduciary relationships, and we have the affects mental capacity. So what is the authority based relationship? It is in between the employer and the employee. So here it is not necessary to get any permission. There is the undue influence assumed without any effect or cause. So if an employee complains, certainly other party have to accept that there can be the undue influence. So then we have the police officer and the accused, and then we have the tax officer and the taxpayer. So in fiduciary relationships, we have the parent and child, guardian and minor, lawyer and client, trustee and beneficiary, fiancé and fiancée. Then what is in affects mental capacity, we have the doctor and patient, medical attendant and patient, agreements with the elderly person. So certainly the burden of proof will rely on the affected party that will be affected from the undue influence. It has to prove that there was the undue influence to get the consent from the offerer or the offeree. So that is the affected party. So if there is no any undue influence, the certainly the party who want to cancel the contract must prove that undue influence was involved. So effect of undue influence become the voidable contract upon the affected party. If it wants to cancel the contract, then it can be cancelled, or if it want to continue with the contract, then they can continue with the contract. So then we have the court's discretion. The court may choose to set aside the contract, absolutely fully cancel contract or specific terms and conditions, especially if the weaker party has already received some benefit from the contract. So I hope you understood the concept of the coercion and the undue influence. Now we are moving forward to the misrepresentation. So what is the misrepresentation? So misrepresentation occurs when a person makes a statement they believe to be true but it is actually false. So misrepresentation can be of the error from the law or error from the contractor. So a person gains an advantage due to breach of duty without intending to deceive. A party innocency caused the other party to make mistake regarding the nature of quality of the contract subject. So what are some essentials of misrepresentation by a party to the contract? The false representation or representation must be factual, acted upon the misrepresentation. So what is the by a party to the contract? The representation must be made by one of the contracted party or their agent. Representations must be made by strangers do not affect contract's validity. Then we have the false representation that include the statement must be false but the party making it believes it to be true and does not intend to deceive. So there must not be the intention to deceive. It might be the error from the contractor or the law. So then we have the representation must be factual. It only facts qualified as misrepresentation. Opinions or intention do not count in the misrepresentation. So acted upon the misrepresentation explains that the misrepresentation only applies if the other party relied on it when entering the contract. So what are the effects of misrepresentation on the contract become voidable at the option of the aggrieved party. The aggrieved party has two choices. It can rescind the contract, it can cancel the contract, or enforce the contract and claim compensation or any losses due to the misrepresentation. So what are the exceptions to the voidable contract due to misrepresentations? That include the contract will consider it voidable if the aggrieved party has the means to discover the truth with ordinary care and diligence. The aggrieved party did not rely on misrepresentation when deciding to enter the contract. The aggrieved party accept or benefit under the contract after becoming aware of the misrepresentation. Then it is impossible to restore both parties to their original positions before the contract. So I hope you understood the concept of misrepresentation. Now we are moving forward to the fraud. So what is the fraud? Fraud involves acts done to make contract with other party by deceiving them with the intention. So it is known as the fraud. False representation. Person gives representation as true which he knows to be false. So active concealment, actively taking steps to cancel defects so that reasonable examination does not find them. Then we have the imperative promise, that promise without intention of performing it. Then we have the fitted act, any act fitted to deceive. So I hope you understood the concept of fraud. We will continue it from our next lecture.